Hello, and welcome to Mackenzie Friend. Today we're going to look at disciplining a child. But first, the usual disclaimer. Whilst I hold a law degree majoring in family law, I do not practice or seek commission. This is for general information only. Any specific questions should be directed towards an accredited specialist family lawyer. So firstly, let's look at the issue. In family law proceedings, parents are sometimes concerned that the other parent will make allegations of abuse or family violence with respect to disciplining of a child. Looking at social science, a study by the Australian Institute of Family Studies showed that there is an association between the use of spanking and the risk of physical abuse. Corporal punishment and physical abuse are both affiliated with similar negative child outcomes. Being physically punished as a child is linked with being more supportive of using corporal punishment as an adult. Let's look at the legislation. In New South Wales, we have the Crimes Amendment and Child Protection Physical Mistreatment Act of 2001. Where it states that a force applied to any part of the head or neck of a child or to any other part of the body that results in bruising, marking, or other injury lasting longer than a short period is unreasonable. Now we'll look at some case law. This is from the well-known smacking grandparents case. In this matter, the grandparents were successful in retaining custody of the 9-year-old after the Department of Family and Community Services tried to remove the child from their care because the child was smacked and his toys removed as a form of discipline. The decision, the federal magistrate found that there was no cogent evidence that the child was at risk of significant harm or indeed of any harm from his maternal grandparents. So looking at the considerations with respect to what reasonable physical punishment is, it will depend on the age and size of the child, the method of punishment, the child's capacity for reasoning, whether the child is able to comprehend correction and discipline, and the harm caused to the child. Looking at some case law, in Geary and Madigan and Anor in 2016, in this case, the family court noted that although community standards have now deemed punishment in that form to be obsolete, it is still not necessary abuse as defined in Section 4 of the Family Law Act. It is only abusive if it is disproportionate to the misbehaviour sought to be corrected. Looking in the Police and DM in 2016 South Australian case, the South Australian Supreme Court judge quashed a father's conviction of aggravated assault for smacking his 12-year-old son. His Honour Justice Peake held that the manner of the correction must not be unreasonable. Matters to be taken into account in making his assessment included whether the child is sufficiently old to be physically corrected, the child's sex and physical development, whether the correction was administered by hand or with an implement, the nature of the physical correction, and the nature of any injury or pain produced. Also, Justice Peake stated that father smacking was not unreasonable and was generally intended to correct the child's misbehaviour. He also held that the suffering of some temporary pain and discomfort by the child will not transform a parent attempting to correct the child into a person committing a criminal offence. So in conclusion, any form of discipline must be reasonable and appropriate. The use of discipline is not necessarily a criminal offence or an act of family violence. A disagreement about how a child is disciplined is merely a decision left to a parent's discretion on a day-to-day basis whilst the child is in their care. If raised, the court will consider the issue from the child's best interests, the merit of such an allegation, and if such an allegation was intended to achieve advantage in proceedings or unreasonably interfere with the other parent's parenting decision whilst the child is in their care. Hope this helps. Thank you.